Namaskar. In this video series on the refresher manual on execution matters for the staff of Punjab, Haryana and Chandigarh UT district courts, today we shall be looking into certain other aspects of chapter 4, which deals with modes and procedure for execution. Today, we shall be looking at custody and disposal of attached movable property pending sale, attachment of agricultural produce, attachment of immovable property, execution by way of delivery of possession. Let me take you to this part 4 of chapter 4. Custody and disposal of attached movable property pending sale, Order 21, Rules 43, 43A to D, CPC, and Volume 1, Chapter 12, Part K of High Court Rules and Orders. Where the property to be attached is movable property other than agricultural produce in the possession of the judgment debtor, the attachment shall be made by actual seizure and the property shall be kept by attaching officer bailiff either in his own custody or in the custody of one of his subordinates who shall be responsible for due custody, provided if the property seized is subject to speedy and natural decay or when the expense of keeping it in custody is likely to exceed its value, the attaching officer may sell it at once with orders of the court. Where the property attached consists of livestock, agricultural implements, or other articles which cannot conveniently be removed and have not been sold by attaching officer, then he either at the instance of the judgment debtor or decree holder or any other person having interest in such property, leave it in the village or place where it had been attached in the charge of the person at whose instance the property is retained in such village or place if such person enters into a bond in form number 15A of Appendix E to the schedule with one or more sufficient sureties for its production when called for, or in the charge of an officer of the court if suitable place for its safe custody be provided and the remuneration of the officer for a period of 15 days at such rate as may be fixed by the High Court from time to time be paid in advance. In the charge of a village lambardar or such other respectable person as will undertake to keep such property subject to the orders of the court if such person enters into a bond in form number 15B of Appendix E with one or more sureties for its production. We have also provided the staff in this manual pro forma number 15A, which is bond for safe custody of movable property attached and left in charge of person interested and sureties under Order 21, Rule 43, and also form number 15B, which is bond for safe custody of movable property attached and left in charge of any person and sureties under Order 21, Rule 43, Subrule 1, Clause C. Whenever an attachment made under the provisions of this rule ceases for any of the reasons as specified in Order 21, Rule 55 or Rule 57 or Rule 60 CPC, the court may order the restitution of the attached property to the person in whose possession it was before attachment. When property is made over to custodian, the schedule of property annexed to the bond shall be drawn up by the attaching officer, bailiff in triplicate and dated and signed by the custodian and his sureties, the officer of the court bailiff made the attachment, the person whose property is attached and made over, two respectable witnesses. One copy will be sent to the court by attaching officer and placed on the record of the proceeding under which attachment was ordered. One copy will be made over to the person whose property is attached and one copy will be made over to the custodian. Order 21, Rule 43 CPC as amended. The pro forma of the schedule of the property is also given in the manual under Volume 1, Chapter 2, 12K. This is the pro forma. Light and readily portable article of all kinds, including jewels, shall after seizure be taken to the executing court and hand over to officer as directed by the court. Note, such property when placed in the custody of the Nazir may be placed by him in his cash chest and lodged in the outer room of treasury if it is open as provided in order 4 subrule 2 of the Punjab Treasury Manual. If it is closed, the presiding officer of the court must make other suitable arrangement for its safe custody. In case the attached property is kept in the village or place where it is attached, the attaching officer shall forthwith report the fact to the court along with list of the property seized. If attached property is neither sold nor retained in the village or place where it is attached, it shall be brought to the courthouse and delivered to the proper officer of the court. A custodian may at any time terminate his responsibilities by giving notice to the court and delivering the property to the proper officer of the court against proper receipt. Order 21, Rule 43A CPC as amended. If the court directs to release the property, the articles released shall be made over to the person to whom the court orders in the presence of custodian, JD, and the witnesses. In case attached property kept in the village or place where it is attached is livestock, the person at whose instance it is to be retained shall provide for its maintenance, and in case of his failure to do so, it shall be removed to the courthouse. Judgment debtor or any interested person in such stock may make arrangements for feeding the same as may not be consistent with its safe custody. It can also be directed by the court that any sums which have been expended by the attaching officer or care, if not duly deposited or paid, be recovered from the proceeds of property if sold, or be paid by the person who is declared as entitled to delivery before he receives the same. It can also be ordered by the court that any sums deposited or paid under these rules be recovered as cost of the attachment from any party to the proceedings. Order 21, Rule 43B CPC as amended. A note shall be added on the schedule to show what arrangements have been made for its upkeep. If the value of the property is deteriorating, the necessary arrangement shall be made and note be given at the foot of the schedule. However, if JD and DH agree in writing to the immediate sale of the property, the officer shall proceed to sell it by auction forthwith after giving notice to intending purchasers as per the order of the court. A note shall also be given in schedule of modification of arrangements, if any. The decree holder, along with the application for attachment of livestock or other movable property, shall pay into court a sum covering the cost of maintenance and custody of the property for 15 days in cash. If before the expiry of 15 days, the amount of such costs for further period as directed by the court has not been paid on furnishing of report from the proper office, the court may issue an order for withdrawal of attachment and issue direction by whom the cost of the attachment are to be paid. Order 21, Rule 43C CPC as amended. Any person who undertook to keep the attached property shall be liable to be proceeded against as a surety under Section 145 CPC and shall be liable to pay in execution proceedings the value of any such property willfully lost by him. Order 21, Rule 43D CPC as amended. Attachment of agricultural produce. If the property to be attached is agricultural produce, the attachment shall be made by bailiff by affixing a copy of warrant of attachment where such produce is a growing crop on the land on which such crop has grown, or where such produce has been cut or gathered on the threshing floor or place for treading of grain, or the like or fodder stack, or on which it is deposited. Second copy on the outer door or on some other conspicuous part of the house in which the judgment debtor ordinarily resides, or with the leave of the court on the outer door or on some other conspicuous part of the house in which he carries on business or personally works for gain, or in which he is known to have last resided or carried on business or personally worked for gain. Thereupon the produce shall be deemed to have passed into the possession of the court. Order 21, Rule 44 CPC. The state government, by general or special order published in the official gazette, declare that such portion of agricultural produce or any class of agricultural produce as may appear to the state government to be necessary for the purpose of produce until the next harvest, for the due cultivation of the land and for support of the judgment debtor and his family, shall, in the case of all agriculturists or of any class of agriculturists, be exempted from liability to attachment or sale of execution of a decree. The standing crops except cotton and sugar cane are now not liable to be attached or sale for execution of a decree. Section 10 subsection 1 of Punjab Debtors Protection Act 1936. Standing trees apart from land on which they stand are also exempted from sale. Section 10 subsection 2 of Punjab Debtors Protection Act 1936. The court has to make arrangements which are sufficient in nature for custody of the agricultural produce which is attached. To enable the court to do so, every application for attachment of a growing crop shall specify the time at which it is likely to be fit to be cut or gathered, and with every such application, such charges as may be necessary for the custody of the crop until the time at which it is likely to be fit to be out or gathered shall be paid to the court under Order 21, Rule 45, CPC as amended. The judgment debtor may tend, cut, gather and store the produce and do any other act necessary for preserving it, subject to the conditions as imposed by the court regarding this, either in the order of attachment or in any subsequent order. If the judgment debtor fails to do all or any of such acts, the decree holder may, with the permission of court, subject to the like conditions, do all or any of them either by himself or through agent, and the cost incurred by the decree holder shall be recoverable from the judgment debtor as if they were included in or forms part of the decree. If the order of attachment of a growing crop has been made at a time when the crop is likely to be fit to be cut or gathered, the court may suspend the execution of the order for such time as it thinks fit and may make a further order prohibiting the removal of the crop pending the execution of the order of attachment. A growing crop which, owing to its nature, cannot be stored shall not be attached for a period less than 20 days before the time it is likely to be fit to be cut or gathered. Order 21, Rule 45, CPC. Attachment of immovable property, Order 21, Rule 54, CPC, where the court orders with regard to attachment of immovable property by prohibiting the judgment debtor from transferring or charging the property in any way and all persons from taking any benefit from such transfer or charge, it shall also require the judgment debtor to attend court on a specified date to note the date fixed for setting the term of the proclamation of sale. In such case, the Elmad or execution clerk shall prepare 3 copies of the prohibitory order in case the property is land paying revenue to government. In case of other immovable property, only 2 copies shall be prepared by the Elmad or execution clerk. He shall also take care that schedule of the property annexed to the court be it identical to schedule of the property given in the warrant to make attachment valid. Elmad or execution clerk shall issue warrant in pro forma number 24, Appendix E, CPC, and notice to JD to attend the court on the specified date. Pro forma number 24, Appendix E, CPC, has also been provided in the manual for ready reference. This is the pro forma number 24, which deals with attachment in execution, prohibitory order, where the property consists of immovable property under Order 21, Rule 54, CPC. Nazir who has been handed over the warrant shall himself or through his subordinate proclaim order at some place on or adjacent to such property by beat of drum and affix a copy of the order on conspicuous part of the property and then upon conspicuous part of the courthouse. Thereafter he shall himself make endorsement upon the warrant and return it duly endorsed within specified time to the court. If any person has been deputed by Nazir, then he shall submit a separate return stating the manner in which and the day and hour at which he did such act. This return will be attached with the warrant. The copy of attachment is to be affixed Firstly, on the property and then upon the courthouse. Reader should record a note on the warrant of attachment or on file that the specific formalities required by law in this case have been actually complied with. Where the order is for the attachment of the property, which is land paying revenue to the government, the warrant should be in accordance with the provisions of Section 141 of Punjab Land Revenue Act 17 of 1887 be addressed to the collector and be sent through him for execution along with necessary copies to the prohibitory order. The collector and his office will then be responsible for executing it in accordance with the specified legal formalities and to affix the order firstly on the property and then on the courthouse of the judge issuing the attachment and in his own office. The collector will then return the warrant to the court concerned when it has been duly executed with the endorsement under his signature certifying that all the legal formalities required have actually been complied. Payment of drum beating charges may be allowed to be made at the discretion of the district judge, either in cash at the spot or by postal stamp attached to the warrant or Indian Postal Orders, Volume 1, Chapter 12H of Rules and Orders. Where the property is land situated in a village, a copy of order shall be affixed in the office of the Gram Panchayat of that village. Where the property is land situated in a cantonment, copies of the order shall also be forwarded to the cantonment board and to the military estate officer in whose area that cantonment is situated. This order shall also take effect against persons claiming under a gratuitous transfer from the JD from the date of the order of attachment and as against others from the time they had knowledge of passing of the order of attachment or from the date of proclamation, whichever is earlier. Order 21, Rule 54, CPC as amended. Execution by way of delivery of possession, Order 21, Rule 35 CPC and Volume 1, Chapter 12, Part G of Rules and Orders. A decree for delivery of any immovable property may be executed by delivery of possession to the decree holder or person appointed by him to receive delivery on his behalf. If such property is in possession of any person bound by the decree, if necessary, it can be executed by removing any person bound by the decree who refuses to vacate the property. Order 21, Rule 35, Subrule 1, CPC. In such a case, Ahmad or execution clerk shall issue warrant to give possession on pro forma number 11, Appendix E, CPC. In such case, the endorsement on warrant must state that the property was found in the possession of A, naming the person, and that he was one of the persons bound by the decree or held on behalf of one of those persons, that he was required to vacate the property, and that on his doing so, the person entitled under the decree was put in possession, or that on his refusal to do so, he was removed from the property and the person entitled under the decree was put in possession. Volume 1, Chapter 12, Part G of Rules and Orders. We have also provided with pro forma number 11 at Appendix E CPC, which provides for warrant to the bailiff to give possession of land, etc. under Order 21, Rule 35. CPC. This warrant is addressed to the bailiff of the court, and after filling the particulars, it should have the seal and signature of the judge of the court issuing the said warrant. Where a decree is for the joint possession of immovable property, constructive possession, Malkana Kabza, shall be delivered by affixing a copy of the warrant in some conspicuous place on the property and proclaiming by beat of drum munadi at some convenient place the substance of the decree. Here, the bailiff shall make an endorsement on warrant that on what part of the property the copy of the process was affixed and at what place the substance of decree was proclaimed. Order 21, Rule 35, Subrule 2, CPC and Volume 1, Chapter 12, Part G of Rules and Orders. Further, it is mandate that possession of any building or enclosure is to be delivered and person in possession being bound by the decree does not afford free access. The bailiff may, after giving a reasonable warning and facility to women not appearing in public according to the customs of the country, to withdraw, remove or open any lock or bolt or break open any door or do any other act necessary for putting the decree holder in possession. The endorsement should describe briefly the action taken by naming the person who was in possession and was afforded and was given reasonable warning and facility to withdraw. Order 21, Rule 35, Sub Rule 3, CPC, and Volume 1, Chapter 12, Part G of Rules and Orders, where the delivery of any immovable property has to be executed, which is in the occupancy of a tenant or other person who is entitled to occupy the same and is not bound by the decree, the court shall order the delivery by affixing the copy of the warrant in some conspicuous place on the property and proclaiming to the occupant by beat of drum munadi at some convenient place the substance of the decree with regard to the property. Here, the endorsement should state that a copy of the warrant had been put up stating where it was fixed and that the substance of the decree had been proclaimed. Order 21, Rule 36 CPC and Volume 1, Chapter 12, Part G of Rules and Orders. Note, before issuing a warrant for the delivery of immovable property, the court should ascertain from the decree holder or his agent the name of the person whom he believes to be in possession of such property to guide it in selecting the particular mode of delivery suitable to the case. When decree is passed giving possession of agricultural land, the date on which possession delivered should be specified in the decree and orders passed as to any standing crops that may be on the land. If this has not been done, it should be done in the order which is sent to the collector by the court executing the decree. If, however, no date is specified in either the decree or the order and the land of which possession is to be delivered is in cultivating possession of the debtor, the collector should at once refer to the civil court for instructions as to whether or not he is to delay the execution of the decree until any crop which may have been sown by the judgment debtor and is standing on the land has been removed. Volume 1, Chapter 12, Part G of Rules and Orders. On return of warrant of attachment or possession served, Elmeth or execution clerk shall place the same on concerned file and report on left hand side under the order of previous date. On the order of the presiding officer regarding satisfaction of decree and consignment of file, the file shall be consigned to the record room and Elmeth or execution clerk shall make entries in remaining columns of register number 10. Note, all miscellaneous applications like an application for deposit of subsistence allowance or objection or an application under section 58 CPC etc. shall be entered in register number 11, register of miscellaneous application and execution proceedings to be maintained by Elmeth or execution clerk. So this is all about chapter 4 part 4 pertaining to the custody of the movable and how the warrant of attachment are to be looked into on immovable property, etc. In our next session, we shall deal on some other aspects of procedure and mode of execution. Till then, namaskar.